Welcome to the deep dive. We're zeroing in on a really vital area of trust law today. Formalities and constitution.
Hmm.
You've got the three certainties, sorted, intention, subject matter, objects. That's your foundation?
Right. Basics.
Exactly. But even when they're clear, there are often these, extra steps. Specific formalities you absolutely have to get right.
Yeah, to actually create the trust properly
Yeah.
and deal with the equitable interests.
It's like you have the blueprint for the house, sure, but this is about actually, laying the foundation, building the walls.
Precisely. It's moving beyond just wanting a trust to the practical side, setting it up, transferring the rights.
So today we're focusing mainly on inter vivos trusts. Those set up during someone's lifetime.
That's right, living trusts. We'll touch on testamentary ones, the ones in wills, but briefly. The thing there is, if the will itself is valid under the Wills Act, any trust inside it, well, it automatically meets the formality requirements.
Okay. So the mission for this deep dive then is to really unpack these extra steps for living trusts, understand why they're so crucial.
And hopefully give you a clear picture without, drowning you in jargon.
Let's do it. Okay, first things first. What exactly is an express inter vivos trust?
Well, simply put, it's a trust someone deliberately sets up while they're alive.
Okay.
And there are basically two main ways this happens. First, the settlor, that's the creator, transfers legal ownership of the property to a trustee,
Right.
who then holds it for the beneficiary. Or second, the settlor just declares that they will now hold their own property as trustee for the beneficiary. Self-declaration.
Got it. So option one, title moves from owner A to trustee B, who manages for beneficiary C.
Yep.
Option two, owner A just sort of puts on a trustee hat and holds it for C.
Exactly. They shift their role. And that brings us nicely to constitution, especially for that first scenario, the transfer one.
Constitution, making sure the keys are actually handed over.
Pretty much, yeah. It's the process of properly vesting the legal title in the trustee or trustees. It's absolutely fundamental.
Yeah.
If the trust isn't properly constituted.
The whole thing falls apart.
Generally, yes, the trust fails.
So how does a trust get constituted? What are the main ways for these living trusts?
Well, our sources point to three key methods. The most common is that transfer to a trustee we just mentioned. Settlor gives ownership to a third party.
Okay.
And for this to work, that transfer has to be complete. And what complete means really depends on the type of asset.
Right. Different rules for different things. Okay, what's the second way?
Self-declaration. We touched on this. The settler just says, right, I now hold this property on trust for X.
So no transfer needed there because they already own it.
Exactly. The focus shifts to making that declaration absolutely clear and legally effective.
Makes sense. And the third one was fortuitous vesting. Sounds a bit like luck.
Huh. It is a bit like that. It's less common. It's when the person who was meant to be the trustee, or maybe was meant to get a gift that failed, somehow gets the legal title later through another route.
Like accidentally.
Well, unexpectedly, perhaps. We'll actually come back to this when we talk about exceptions later on. It links into Strong v. Bird.
Okay, interesting. So we have these ways to set up a trust, but there's this big principle hanging over it all. Equity will not perfect an imperfect gift.
And equity will not assist a volunteer.
Yes.
What does that actually mean for you listening, who's a volunteer?
Right. A volunteer, in this legal context, is someone who hasn't given valuable consideration. So they haven't paid money or money's worth for a promise or benefit they're getting.
So like someone receiving a gift.
Exactly. And the implication of these sayings, these maxims, is huge. If someone intends to give something away, maybe as an outright gift, or maybe by setting up a trust with a trustee,
Right.
but they don't quite finish all the legal steps needed for that specific method they chose. Equity, the fairness part of the law, generally won't step in and fix it for them. It won't say, oh, the gift failed. Let's just pretend they meant to declare themselves a trustee instead.
So the courts stick to what the person tried to do. If method A fails because you missed a step, they won't just switch it to method B for you. That's the general rule, yes. And the classic case here, the one everyone learns, is Milroy v. Lord, way back in 1862.
Okay, let's get into Milroy v. Lord. What happened?
Okay, so you had Mr. Medley. He wanted to give 50 bank shares to Mr. Lord to hold on trust for his niece, Mrs. Milroy.
Straightforward enough so far.
Well, the bank had specific rules. To transfer shares, you needed them registered in the bank's books. Medley signed a document, gave Lord a power of attorney to sort it out.
So he took some steps.
He did. But crucially, Medley died before Lord actually got the shares registered in his name as trustee. That final, vital step.
Ah, So the registration never happened. What did the court say?
No valid trust. Medley's clear plan was a trust created by transferring the shares to Lord.
Not by declaring himself trustee.
Exactly. And because that transfer to Lord was incomplete legal title, hadn't passed without the registration, the trust failed. The court famously said the settler must do everything necessary for that specific type of property to transfer it.
And equity wouldn't just change the plan and say, oh, well, looks like he declared himself trustee instead.
Nope. They wouldn't rewrite his intention. The failed transfer stayed a failed transfer. The big lesson is your intention isn't enough.
Right.
You have to do the right legal actions. No shortcuts.
Wow. That really hammers it home. Get the steps right. Okay, quick recap then. Crucial steps for these express inter vivos trusts.
Okay, first, if you're transferring to a trustee, you must transfer legal title correctly for that specific asset. Complete constitution is the name of the game.
And that correct bit depends on the asset.
Absolutely, we'll dig into that. Second, if you're declaring yourself trustee, that declaration needs to be totally clear, unequivocal, no doubt about your intent.
Right. And you mentioned the type of property dictates the formalities. Personality versus realty. Can you just remind us what those are?
Sure. Personalty is basically movable stuff. Chattels, your belongings, furniture, cars, but also things like money in the bank, shares in a company, intangible things too.
And
Realty is land, real property, land and buildings, anything fixed to it. And the rules for creating trusts are quite different depending on what you're dealing with.
Okay, let's start with personality then, the movable stuff. What are the rules there for declaring a trust?
Generally, for personality, there aren't specific written requirements just for the declaration itself. An oral declaration can be enough.
Just saying it out loud.
As long as those three certainties, intention, subject matter, objects are clear, yes, an oral declaration can work.
And there's a case for that. Paul v. Constance.
Yep, Paul v. Constance, 1977. Classic example. You had Mr. Constance and Miss Paul, unmarried couple. Money in an account, just in his name, some from an injury claim, some joint bingo winnings.
Okay.
And he kept saying to her, the money is as much yours as mine. Repeated.
The magic words, maybe.
Well, when he died without a will, his estranged wife tried to claim it all.
But the court looked at those words.
They did. The Court of Appeals said his words, plus his actions, like putting joint winnings in there, showed a clear intention to create and express trust for himself and Mrs. Paul jointly.
So those repeated statements were enough.
Enough to show he saw himself as holding it on trust. And crucially, because it was personalty money, no writing was needed for the declaration.
So just declaring a trust over, say, cash or jewelry, a clear verbal statement can do the job.
That's the general idea for the declaration itself. But, and this is important, that's different from actually transferring the personality if you're appointing someone else as trustee.
Right. So I can verbally declare the trust. But if my friend is the trustee of my guitar for my nephew, I still need to actually give the guitar to my friend.
Exactly. You still need to transfer the legal ownership correctly. For chattels, like the guitar, that usually means physical delivery with the clear intent to give it. Or you could use a formal deed of gift.
Like in that recall case, we're saying it's all yours about furniture wasn't enough without handing it over.
Precisely. No delivery, no transfer of the chattels in that instance.
Okay. What about shares? That sounds more complicated than just handing something over.
It is, definitely. For shares, just saying you declare a trust or gift them doesn't cut it legally. Milroy v. Lord showed us that.
Right, the failed registration.
Yep. You typically need to fill out and sign a stock transfer form, hand that over with the share certificate to the trustee, and then the company has to actually register the change in their books. Legal title only really passes when that registration is done.
Okay, lots of steps for shares, right? That's personalty. Now, realty land, I sense stricter rules coming.
You sense correctly. Land brings in specific laws. For declaring a trust of land, the big one is Section 53(1)(b) of the Law of Property Act 1925.
Section 53(1)(b). Okay, what does that say?
It says the declaration must be manifested and proved by some writing signed by the person declaring the trust.
Manifested and proved by some writing. Does that mean the writing has to be there right at the start?
Not necessarily. You could, in theory, declare it orally first. But that oral declaration isn't enforceable in court unless and until you have some signed written evidence of it.
So the proof can come later.
Yes, like in Gardner v. Roe. The key is getting that signed written proof confirming the trust exists in its terms. Doesn't have to be a super formal deed for the declaration itself. Maybe a signed letter could work.
And if you never get that written evidence,
then the trust of land is unenforceable. You can't make it stick in court. But there's a big exception. fraud.
Equity stepping in again.
Exactly. Equity won't let someone use this rule, the need for writing, as a cover for fraud. If someone gets land based on a verbal promise to hold it on trust, then tries to keep it for themselves saying, no writing, equity might intervene, like in Rochefoucauld v. Boosted.
Good. Stops people using the law dishonestly. Okay, that's the declaration. What about transferring the legal title of land to a trustee? More rules.
Oh, yes. Section 52 of the same act, the Law of Property Act, 1925. It says any transfer of land to create or convey a legal estate must be by deed.
By deed. Okay, what makes something a deed?
There's a formal legal document. Section 1 of the Law of Property, Miscellaneous Provisions, Act 1989, sets out the requirements. It needs to be clear it is a deed signed by the person transferring, their signature witnessed and delivered, which usually just means it's dated and intended to be effective.
So signature, witness, clear intention.
Yes. Think of it as the legally heavyweight way to transfer land.
So putting it together for a trust of land where I appoint a trustee, I need signed written evidence of the declaration.
Under Section 53(1).
And I need a separate formal deed to actually transfer the land title to the trustee.
Under Section 52(1). And one more thing for most land now, it's registered land.
Land registry.
Yep. The transfer isn't truly complete until the trustee is officially registered as the new owner at HM Land Registry.
Wow. Okay, so for a land trust with the trustee, written declaration evidence, deed of transfer, and registration, lots of hoops.
Definitely potential pitfalls. Which leads us to common issues.
Where things go wrong. I bet that Milroy v. Lord principle pops up again. Failed transfer isn't a self-declaration.
Absolutely. It's central. If you try to transfer to a trustee but mess up the steps, the court won't just say, oh, okay, we'll treat it as if you declared yourself trustee instead.
Yeah.
They respect the intended method.
And a failed gift doesn't become a self-declaration either, that Jones v. Locke case.
Exactly. The father, the check for the baby, I give this to baby. But you didn't properly endorse it or anything?
Took it back.
Yep. Court said, failed gift. And crucially, they refused to say his actions meant he was holding it on trust. His intention was a gift, it failed, end of story. Equity wouldn't magically turn it into a trust.
So what you meant to do really matters. If you aimed for a gift and failed, it stays a failed gift.
Precisely. Same logic if you aim to transfer to a trustee and fail. It doesn't become a self-declaration. Look at Richards v. Delbridge.
What happened there?
Grandfather wrote on a lease document, basically, I give this to my grandson.
Yeah.
But transferring a lease legally needed a formal deed. He didn't do one.
So, failed transfer.
Failed gift of the lease, yes. And the court said, nope, this isn't him declaring himself trustee of the lease either. Intended gift failed, that's it.
Okay, these cases really drive home how vital getting the formalities right is, depending on exactly what you're trying to do. Gift, trust with trustee, self-declaration.
Absolutely critical. Now, we did have a couple of examples of trusts working.
Right, Paul v. Constance, the bank account, where the words were enough for personality.
Yep. And the other one was interesting, T. Choithram International v. Pogarani. Charitable trust. Settler was also a trustee.
Yes. Tell us about that one.
Okay, Mr. Pogarani, very wealthy man. He declared orally that he was giving all his wealth to a foundation structured as a trust. He signed the trust deed, and importantly, he himself was one of the trustees.
Okay, so he's on the board, so to speak.
Exactly. But he died before all the assets were formally transferred to all the trustees. So technically, the transfer wasn't fully complete.
But the court upheld it, even though the transfer wasn't finished.
The Privy Council did, yes. Their reasoning was, because Pogarani was already one of the trustees, his own conscience was bound the moment he made that declaration.
Because he held title, at least partly, as trustee.
Precisely. They said equity will not strive officiously to defeat a gift, especially when the donor is also a trustee. It's seen as maybe softening the strict rules slightly, but it really hinged on that fact. Donor was also a trustee.
Okay, so the main takeaway is still, plan carefully. Get the formalities right for the declaration and the transfer. Because usually, equity won't bail you out if you mess up.
That's the default position. However, and this is really important, there are established exceptions. Ways an intended gift or trust can be enforced even if the formalities aren't perfect.
The exceptions to equity won't assist a volunteer. These sound useful.
They can be crucial. It's like equity has a fairness override button sometimes.
Okay, what are the key ones we should know about?
Well, there's the rule in Strong v. Bird that links back to the fortuitous vesting we mentioned. An incomplete gift might get perfected if the intended recipient ends up being the executor of the donor's will.
Okay. What else?
Donationes mortis causa deathbed gifts.
Mm-hmm.
Very specific rules for those. Gifts made anticipating death.
Right.
Then there's the every effort test from Rose. If the person transferring has done absolutely everything they can do, but it needs a third party, like a company registrar, to finish it,
Mm-hmm.
equity might say the transfer is complete from the point the transferor did their bit.
So it's treated as done earlier.
In equity, yes, a constructive trust can arise. Then there's a more recent, sometimes debated one, based on unconscionability, Pennington v. Waine.
Unconscionability. That sounds like it depends heavily on the facts.
Very much so. Is it just plain wrong?
Yeah.
Unfair for the donor to go back on their word? And finally, a really significant one, proprietary estoppel.
Proprietary estoppel. Okay, what's the essence of that?
It's an equitable idea that can stop a landowner backing out of a promise or assurance about their land.
Okay.
If someone else has reasonably relied on that promise, suffered some loss or disadvantage because of detriment,
Right.
and it would just be fundamentally unfair, unconscionable for the landowner to then renege, it can even create property rights for the person who relied on the promise.
So, classic example. Someone promises you the farm. If you work it for low wages for years, you do it, then they change their mind.
That's exactly the kind of scenario where proprietary estoppel might kick in, though it's always fact-dependent. You need that clear enough assurance, doesn't have to be explicit. Authority View Major showed that.
The farm case with indirect assurances.
Yes. Then reliance on it. Then detriment, like working for low pay, missing other chances, like in Gelid v. Holt. Spending money on improvements could also be detriment.
And it has to be unconscionable to go back on the promise.
That's the final crucial element. Would it be shockingly unfair? Context matters, like in Yeoman's Roe v. Cobb. In a commercial setting between experienced people, a failed negotiation wasn't necessarily unconscionable.
And that Pennington v. Waine unconscionability test you mentioned before,
Well,
how does that differ? Is it broader?
Pennington applied unconscionability directly to perfect an incomplete gift of shares, arguably extending Rose. It focused on whether it was unconscionable for the donor to retract after the donor had been told about the gift and acted on it, becoming a director. Proprietary estoppel is more focused on promises about land and detrimental reliance creating inequity. So related concepts of fairness, but applied in slightly different contexts.
Okay. And how does proprietary estoppel link back to trusts? Can it actually create one?
Yes, it can. If a claim succeeds, the court looks for the minimum needed to do justice. That might be ordering the land transferred, giving a right to live there, or imposing a constructive trust.
A constructive trust one the court creates.
Exactly, to stop unjust enrichment or satisfy the equity raised by the estoppel. So estoppel can lead to trust-like rights arising, even without the usual writing needed for land deals. Section 5.3 of the LPA 1925 actually acknowledges this, so that the writing rules don't stop constructive trusts.
So these exceptions add some vital flexibility, where rigid rules would cause real unfairness.
Precisely. They show that while formalities are important, equity has these safety valves based on fairness and preventing unconscionable behavior.
Okay, one more big area. The rules against perpetuities. What's the worry here? Why do we have these rules?
It's about stopping people controlling property from beyond the grave for too long. The dead hand control idea. The law wants property to eventually be freely transferable, not locked up forever in complex trusts.
Makes sense. So how do the rules work?
There are two main parts, though modern law simplified one significantly. First is the rule against remoteness of vesting. When do beneficiaries' interests have to be certain?
Okay, and what's the rule now?
For trusts set up after April 6, 2010, the Perpetuities and Accumulations Act 2009 brought in a fixed period, 125 years.
125 years. Simple enough.
And the big change was the wait-and-see rule. Instead of invalidating a trust if there's some tiny theoretical chance an interest might vest too late, we now actually wait and see.
So you wait for up to 125 years.
Exactly. If the interest does vest within that time, it's fine. If it becomes clear it won't vest within 125 years, then it fails at that point. Much more practical.
Definitely sounds better than killing a trust based on some wild hypothetical. What was it like before 2010? Briefly.
Bit more complex. The 1964 Act allowed a choice. A fixed period up to 80 years, or the old common law life in being plus 21 years. It also had a type of wait and see. Before that, common law was super strict. Any possibility of vesting too late, however remote, made it void from the start, no waiting. But for trusts now, that 125 years and wait and see is the main thing.
Got it. And you said there was a second rule about duration for non-charitable purpose trusts.
Yes. These are the unusual ones, trusts for pets, specific monuments, that kind of thing. Most fail anyway for lack of beneficiaries.
Right.
But for the few that are valid, there's a separate rule limiting how long they can last, to stop property being tied up forever for a purpose rather than people or charity.
And what's the time limit for those? Is it 125 years too?
No, crucially, the 2009 Act specifically says the 125-year period does not apply to the duration of these trusts. Section 18 makes that clear.
So what rule applies then?
They're still stuck with the old common law duration rules, usually a relevant life in being plus 21 years, or more practically, a fixed period of up to 21 years. You sometimes see trusts worded for as long as the law allows.
And that means?
Courts usually interpret that as 21 years, like in Re Hooper. Oh, and vitally, registered charities are completely exempt from all perpetuity rules. They can last forever.
Okay, quick summary on perpetuities. Trusts for people or charity interests must vest within 125 years. Wait and see. Non-charitable purpose trusts limited duration based on older common law rules, often 21 years.
You've got it. It's all about balancing the settler's wishes with keeping property freely circulating in the long run.
Fantastic. We have covered a huge amount today. Really important stuff.
Definitely.
So just to recap the big points. 3 certainties are step 1, but formalities and constitution are the essential next steps to make a trust legally real.
Yep. Different rules for personality and realty land needs that signed writing.
And the big principle, equity usually won't fix mistakes for volunteers, people who haven't paid.
But there are those crucial exceptions. Strong v. Bird, deathbed gifts, Rerose's every effort rule, Pennington's unconscionability idea, and proprietary estoppel.
Don't forget those exceptions. And finally, the perpetuity rules limiting how long trusts can tie up property.
Absolutely. Understanding all this is vital, especially if you're advising on trusts or dealing with messy situations where things maybe weren't done perfectly first time round. Knowing when equity might step in is key.
So for you listening, definitely review your notes on this, maybe work through some problem questions, and keep those key laws in mind. Section 53(1)(b), Section 52(1) of the LPA 1925.
Section 1 of the LPMPA 1989 for deeds.
And the Perpetuities and Accumulations Act 2009.
Yeah.
If any questions pop up later, do email us, faq@seelytraining.com, or of course, use the in-app AI tutor.
Please do.
Thank you so much for joining us for this deep dive. We'll be back very soon with another exploration into the law.